Okay, so we're back, and I said at the end of the last lecture we'd discuss the Rehnquist court and free exercise. And this involves consideration of a new test that the court introduced during the Rehnquist years called the Smith test. Now, last time we were discussing these early tests that attempted to create an understanding of where the state's interest in creating order through generally applicable neutral laws ended, and where an interest of the individual in the free exercise of religion began. And we saw throughout that lecture that the pendulum swung back and forth. It started with Reynolds, in which the court said that religions that didn't exist at the time of the founding or the framing of the Constitution received less protection. Furthermore, the state could ban certain practices that tended to threaten social order. And then it swings, beginning with the valid secular policy test and continuing through what's called the Sherbert-Yoder test. It swung back toward the individual, the protection of the individual right, requiring government to come up with a compelling interest for the regulation and not creating an exception for religious practice, and then also to demonstrate that it had implemented its policy using the least restrictive means. And then we see, using that same test, the pendulum swings back again toward protecting the regulation, as we see the court coming up with more and more instances in which the state has met its compelling interest burden. So the Rehnquist court then kicks off with, you might expect, the pendulum swinging back in a case called Hobby versus Unemployment Appeals Commission, 1987. The court applies the compelling interest test to the situation involving Hobby and unemployment benefits, and it actually applies this compelling interest test exactly as it did in Sherbert to rule in favor of the free exercise of religion and rule in favor of Hobby. And at that point, Justice Brennan actually uses the term strict scrutiny to describe the type of test that the court is applying to governmental policies. Remember, strict scrutiny, we're talking Caroline Products, we're talking Korematsu, the modern tests for due process and equal protection that places the burden on government, and government must demonstrate that the policy is necessary, that it meets fulfills some compelling interest, and then has been implemented using the least restrictive means. So that really gives people pause. And after Hobby, the Rehnquist court, actually the pendulum swings back towards supporting the regulation. The Rehnquist court begins chipping away at this high standard, what counts as a compelling interest, and allowing, upholding more governmental regulation. And that brings us to a case called Employment Division of Oregon versus Smith. This case was decided in 1990, and the majority opinion was written by Justice Antonin Scalia. In this case, the court considers a question about the denial of unemployment benefits. Now, these individuals, Smith and the other individual who sued, lost their jobs because they had violated some general law. Okay, now let's think about this, though. So Smith was a drug counselor working for the state of Oregon. I'm sorry, probably working for a private company that had contracts with the state of Oregon. And of course, drug counselors have to be drug-free, so Smith was given regular drug tests, and he failed a drug test, and he was fired. He explained that being a Native American, he ingested peyote as part of a religious practice, but he understood that being a drug counselor meant that you probably had to be drug-free. So he accepted the fact that he was fired, and he did not contest it. What he did contest, though, was the denial of unemployment benefits. Now, he violated a general law he wasn't convicted of a crime or even accused of a crime. He was just fired for cause. And he said, well, I should get unemployment benefits because the cause I was fired for was related to my religious convictions. I understand that I can be fired from the job, but I don't understand why I'm being denied unemployment benefits. So the question here is, can an individual get a get out of jail free card kind of thing, at least with respect to the provision of unemployment benefits, not getting out of a criminal statute, of course, but can a person still get unemployment benefits for violating a generally applicable law, even where the person's actions were based on religious convictions? This law, there's absolutely no doubt, it was general, it was neutral, and it was neutrally applied by the state of Oregon. Oregon did not pass this law requiring drug counselors to be drug-free, nor did it pass the policies related to denial of unemployment benefits to target religion specifically. But the question then is, should the state make an exception for religious practice when it comes to things like being fired for drug use? So, may the state deny unemployment benefits? The court says yes. 6-3 vote. And the court says that while a non-discriminatory religious practice exemption is permitted, it's not required. So Oregon could provide an exception if it wanted to. In this case, it didn't provide the exception for religious practice to its drug laws and unemployment laws policies, but it's not required to do so. And in Smith, the court says, in Smith, the court says that religious practice is not exempt from generally applicable, neutrally applied laws that are designed to create social order and that are not designed to target any particular group or interest. One does not get a pass or an exemption as a matter of right, as a matter of constitutional right, where we're talking about a law of general applicability. Now, Smith has been limited, actually, in its application primarily to criminal laws. So people don't get to get out of criminal statutes because of religious practice. And of course, we understand that to mean primarily drug laws. So what happens after Smith? Well, as we can see, the court has come full circle back to Reynolds, okay, in terms of this belief-action dichotomy and erring in favor of the government regulation rather than the religious practice. This incidental impact test is kind of like the Smith test. It is the Smith test, but it's another term for it, where a generally applicable, neutrally applied law, neutrally enforced law, incidentally burdens religion, individuals cannot claim a violation of their free exercise rights. Well, here is a case. It's perhaps my favorite case name in the history of case names. I like to say it a lot. It rolls off the tongue. Church of Lukumi Babalui versus the city of Hialeah, Florida. So the Church of Lukumi Babalui, I really enjoy saying that. Church of Lukumi Babalui was a Santerian church, and the Santerians are a sect that bases their religious practice upon the sacrifice of animals and then the cooking of these animals, right, the preparing of them for ingestion. And so the city of Hialeah is a very nice little retirement community in Florida, and all of a sudden they see the Church of Lukumi Babalui moving in. These Santerians are moving in, and they're creating pens for animals. They're holding these animals. They're sacrificing everything: doves, chickens, pigs, goats. They're making all of these sacrifices, so the city council is all up in arms about this, and they pass a neutral law that is generally applicable that says that no person can butcher animals within the city limits of the city of Hialeah without obtaining a permission, a certificate from the city. It's a local ordinance. The court strikes it down. It says, yep, it's neutral on its face, but it's non-neutral in its application. It was intended purely to target the Santorians. However, the court could not agree on what standard to use. They certainly didn't apply the Smith test here. Some of the justices applied the Sherbert-Yoder test. The court couldn't agree on the standard to use, but they all agreed on one thing, that the city ordinance violated the Santorians' free exercise rights, despite their despite the neutrality, facial neutrality of the ordinance. So yeah, look at this. Lukumi Babluai was a unanimous decision, even though the court fractured on what rule to apply. The outcome was the same. This is one of the reasons why I emphasize the rule so much, is because it doesn't necessarily dictate the outcome, but it is extremely important for understanding how the court arrives at its decision. Smith, it was a divided court, 6-3, and Lukumi Babluai was unanimous. I think one of the reasons is because it was so clear that the city had targeted religion in the passage of this ordinance. But in Smith, there was no notion that Oregon had passed its requirements for no drug use for drug counselors, and then denial of unemployment benefits to target religion. There was no sense of that at all. Okay, so after Smith, Congress passes something called the Religious Freedom Restoration Act. And this act did a couple things. First of all, it required the court to apply the compelling interest test as set forth in Sherbert versus Verner to any review by the court of congressional action or action of administrative agencies of the national government, and then also for the states. So it was an attempt to force the court to evaluate the actions of state governments under the 14th Amendment using a particular test. All cases where free exercise of religion is substantially burdened, or it's alleged to be substantially burdened. And, and so the court actually did it again, sorry. The court in a case called City of Bernie v. Flores strikes down that portion of the national RFRA which requires the use of the compelling interest test to the states. It leaves in place the application of that test to the national government, but not to the states. This is really interesting. Congress is requiring the court to apply a test that for the most part had been used to strike down congressional and state legislative actions. Don't often see that. But the court strikes down the part that requires them to use Sherbert v. Verner when it comes to state actions. Because going all the way back to the beginning of our class, where the court has said that the 14th Amendment was designed to be remedial in its impact. And Congress is, going back even farther to cases like Marbury, Congress is should not be in the business of telling the Supreme Court how to interpret the Constitution. That's not its job. Okay, so as a final overview, at first we got the Reynolds and Davis cases that said that new and unconventional religions are not protected. It also applied, those two cases applied the concept of police powers and government neutrality to allow the national government and state governments to regulate religious practices, actions that might impact public health, safety, welfare, and morals. Then Cantwell created the belief-action dichotomy. You might want to look closely at Cantwell in your text. And then Sherbert created the compelling interest test, which the court even calls strict in its scrutiny of government actions. And finally, Smith and the city of Bernie v. Flores created the Smith test, or incidental impact test, and the city of Bernie had to do with whether the Sherbert test should be applied to the actions of state governments, and the court said no, Congress can't mandate it. Actually, what happened after that was state legislatures passed their own RFRAs. They passed their own Religious Freedom Restoration Acts that required their own courts to apply the Sherbert test. So thank you very much for listening, and we'll move along.